Good morning, everyone. How are you? It is an honor and a pleasure to welcome you back to the second day of the 2026 Shapiro Environmental Law Symposium. I'm going to say the title, it's not in my remarks, but the title is so inspiring. I do want to just sort of center us for a second. Adapting to paradigm shifts in environmental and energy law in the United States. Today, you're going to hear the second day of a very, very profound, important, timely, and I understand very impactful conversation about adapting to paradigm shifts in environmental and energy law in the United States. I hope you realize what a big mouthful that is. I had the pleasure this morning of having coffee with the amazing Charles Lee, and he reminded me that seeing the United States through a lens of environmental and energy law is one of the ways to see every one of the most pressing social and economic issues of our time. So now I'll say good morning and a very warm welcome to you all. I'm Dana Bowen-Matthew. I have the joy of being the dean of this law school and the honor of welcoming you to the 2026 J.B. Shapiro Environmental Law Symposium. This is the annual signature event of our highly renowned and well-regarded environmental and energy law program. It has a long tradition of addressing cutting-edge issues in environmental and energy governance. In recent years, the symposium has focused on health threats caused by pollution, the urgent need to respond to and prepare for climate change, access by all segments of society to clean and affordable energy, management of the nation's public lands and natural resources, environmental justice, and this year, the shifting boundaries of environmental and energy law. Environmental and energy law in the United States are indeed at a crossroads. This year's symposium is an extraordinarily timely opportunity to talk about climate change, political dynamics, rapid technological change, resource scarcity. You get the point. GW Law is thrilled to host this impressive group of scholars, practitioners, and policymakers from around the nation for 2 days of impactful discussion on one of the most pressing issues of our time. I'm proud to say that GW has been at the forefront of the environmental law education academy for the past century. Our program was established at the beginning of the modern environmental law era and continues to expand and provide the next generation of environmental and energy lawyers with the tools they'll need to tackle the national and international challenges that face our planet and its inhabitants. I'm especially excited to see our students here. We have amazing students. And this morning, you're going to experience an Only at GW Law event. This symposium is one of the many opportunities that our students will receive to have a front row seat to very high-level discussions that actually will shape the way that policy goes forward. There's no better place to study energy and environmental law than here with our all-star faculty. And our all-star faculty couldn't ask for a better set of students with whom to study. Now let me share just a few of the great offerings available here at GW for our students and those who are interested in our environmental and energy law program. 1, we have an active student chapter of the Environmental and Energy Law Association. It hosts programs and events throughout the year, including an annual environmental and energy law career panel called Sustainability Week every fall. 2, we're the proud home of the George Washington Journal of Energy and Environmental Law, affectionately called GEAL. It's a student-run publication that focuses on scholarship at the intersection of energy and environmental law. GEAL is published twice annually and supplements the Environmental Law Report, News, and Analysis. And 3, our prime location in the heart of the nation's capital, where environmental and energy law and policy is debated and made, provides our students with a unique opportunity for externships, and many of the students here have wonderful externships. We call them field placements in some of the most influential government and nonprofit environmental organizations in the world. Every year, we invite our students to compete for the Jamie Grodsky Prize for Environmental Law Scholarship, which honors the life and legacy of Professor Jamie Grodsky, who served with great distinction in our environmental and energy law program before her untimely passing. It is a $5,000 prize that supports and recognizes outstanding scholarship, and I understand that was awarded yesterday. We presented the annual Grodsky Prize to an outstanding GW Law student who wrote the best paper of 2026 on environmental law, David Board. Is David here? David Board. His paper was titled Charting a Course for a Maritime Cap-and-Trade Emission System in the United States. He also serves as the notes editor for the George Washington Journal of Energy and Environmental Law. Congratulations to David. Now I'll conclude with just a few thank yous and let you get to the program. First, I want to say thank you to my friend and colleague, Professor Charles Lee from our fellow DC institution, Howard University. You delivered a powerful keynote speech yesterday afternoon, and you are an inspiration to us all. I'm also grateful to the Environmental and Energy Law Program team. We have an amazing team, Chris Svensson, Claudia Delgado, Giovanna Gismondi, and I thank all of you for your incredible hard work for this symposium. And then last but certainly not least, our outstanding faculty and symposium organizers, Professors Rob Glicksman, Sara Bronin, and Carolyn Seacock. Thank you. Let me conclude by saying thank you to the professors who participated in the symposium as panelists and moderators. They include the amazing Emily Hammond, Don Brayman, David Ullman, Matthew Brotmann, and Larry Weinstock. These are exciting and challenging times indeed for the environment, for energy, and for the planet. I'm thrilled that it is in good hands that I leave you today to take care of all of that. Welcome.
Good morning, everybody. If you have come to hear paradigm shifts in U.S. energy law, you are in the right place. I'm Sara Bronin, I guess on the faculty host committee, and really, really excited to see so many people in the room and to have this amazing panel. As the dean said, the way the U.S. manages, consumes, prices, and cites energy has critical impacts on all of our lives. And I just want to set the stage by mentioning a few basic stats that we talked about as a panel and that we'll cut through all of the presentations. First, energy costs. As you all know, just from your living in the world, energy costs are a pretty significant expense for households. On average, 5 to 6% of the average U.S. household, but those costs are higher for low-income households, 7% on energy burden on average. A quarter of low-income households spend more than 15% of their incomes on energy. And I know to different extents, our panelists today will talk about affordability. Energy costs are also rising. So the Energy Information Administration says energy costs have increased higher than inflation. They've increased about 30% since 2021. So we see these costs rising. At the same time, we see our energy infrastructure aging. Our transmission infrastructure in particular needs to be built up, rebuilt, deployed at rapid scale. I know some on the panel here have worked on transmission policy in various capacities. For my property students in the room, as you listen today, I want you to think about a few things that we've discussed. One, resource extraction. Of course, we've talked about the classic oil and gas, rule of capture, but we're going to, I think, hear about other resource extraction principles today. Property rights, we talked about solar rights and how property rights might improve our ability to deploy solar energy. The siting dimension, we've mentioned zoning, and I'm not sure the panelists are going to get into that themselves, so if you do have a question about that, please queue it up. Just to say, but before turning it over to our panelists, that our problems definitely have something to do with politics, have something to do with markets, labor, equipment, material costs. But the best way for them to be addressed is actually through law. So it's my view, and I know the view of others on this panel, that lawyers have to be on the forefront of tackling the complex issues related to grid governance, energy affordability, permitting, siting, and more. And we have to keep an eye on the international implications of US action. So here, to further diagnose these problems and to solve them entirely in the next 1 hour and 15 minutes are our three outstanding panelists. It's my pleasure to introduce Professor Alexandra Klass, Dr. Carolyn Kissane, and the Honorable Matthew Brotmann. And as they present, I'll just say a little bit more about them before they do so. And I know I was supposed to keep to a sentence, so that's what I'm going to try to do. Professor Alex Klass is the James G. Degnan Professor of Law at the University of Michigan Law School, the former Deputy General Counsel for Energy Efficiency and Clean Energy Demonstration at the U.S. Department of Energy, and one of my oldest friends in the Academy. So very, very delighted to have her here, and I think she's going to go first.
All right, can everyone hear me okay, or can I use that? Excellent. Is that better? Yeah. Thanks so much, Sarah, and it's wonderful to be here at this conference. And thanks for those opening remarks. I think that set the stage really nicely. There's so much that we could talk about in terms of what's happening at the federal level, what's happening at the state level to counteract some of the trends at the federal level these days. But what I'm going to do in my time here is present to you some research that I've done with Dave Owen at UC Law San Francisco that we've really just finished. This is the first time I'm presenting anything with regard to it, and it's looking at how the president currently is using a very narrow statutory authority that was designed for wartime or sudden emergencies to force coal plants that were about to retire to stay open. You may have read about that in the newspaper over the last few months. And really override the roles that Congress has given to an independent agency, the Federal Energy Regulatory Commission, and states to determine to make sure we have enough power online and that we have grid reliability. So basically, the president is working through the Department of Energy, which he has pretty much complete control over, to override the authorities of agencies that Congress had said should be in charge of this issue. There's a lot of litigation going on with regard to this. None of it has been decided yet, but I'm going to give you some background on the history and also just some historical research that we've done to put the exercise of this statutory authority into context, and then also hopefully in the Q&A we can talk about some of the implications of that as well. Okay, so we start with some historical research because I think this is really important. So during World War I, our electric grids were very, very local and not well interconnected. Then all of a sudden there was a big increase in electricity demand to power the war effort. Congress acted. It granted President Wilson regulatory authority over the energy sector, and there was a creation of some new agencies, the Fuel Administration, the War Industry Board, and so they worked together to develop a more sort of interregional and connected electric grid. They were somewhat successful, but it was kind of rocky. So after the war in 1919, the Secretary of War tasked Colonel Charles Keller to report on those shortcomings. Basically, what should we do for the next war? What should we do to have a better grid? This resulted in what is known as the Keller Report that came out in 1921. And he talked about the problems that happened during World War I, and his solution was interconnection, grid integration, making these local utilities, either encouraging them or working to basically interconnect the grid so you can get power to where it's being generated to where it is needed. And he gave lots of examples that some regions, were really struggling to meet power demands to support the war effort, but then there were power plants elsewhere that were just sitting unused or idle. So it's a really early statement of the importance of building transmission, like Sara said before, and interconnecting the grid. So we're thinking about this back in the 1920s. Okay, so between 1918, 1945, there was a lot more interconnection going on. Electricity consumption also grew rapidly. And in 1935, Congress enacted the Federal Power Act. There was already a Federal Power Commission, but it mostly regulated hydropower at that point. This expanded the Federal Power Commission's authority, and now it could regulate the transmission of electric energy and the wholesale sale of electric energy in interstate commerce. Authority over retail sales, and also just what to build, constructing power plants, constructing transmission lines, that remained with the states that regulated the utilities. There was another provision in the Federal Power Act. Congress granted the Commission authority during wartime and sudden emergencies to sort of force interconnections, force power plants to run, and this grew out of the Keller Report and the problems during World War I. And this is this provision, Section 202C, which is kind of the focus of this research. And I've highlighted the key pieces here. So this is power, this time it was to the Federal Power Commission, authority during war or any sudden emergencies, a sudden increase in the demand for electric energy, the commission would have authority to act. Whether it was requested or whether it thought on its own, it could do this to have a power plant keep running, to force two utilities to interconnect their systems. Normally that would be voluntary, but it was an override in these sorts of circumstances. Okay, World War II happens. Electricity demand, of course, increases again significantly to meet to address the war effort. And over the course of the war, the commission used that authority in 202C. It issued 22 orders, and almost all of them mandated interconnections, right? They said, this utility, connect with this utility, connect your systems. And then there was a few as well that said, this power plant needs to run. And so that was exercised during the war. And you can kind of see here, during this time period, how the grid expanded. So we've got 1908, we've got a few more transmission lines and systems in 1918, 1928, 1940, 1949, 1960 looking more like what we have today. So really significant growth here. Okay, so how do we deal with this today? There are two terms that are really important here. One is resource adequacy. How do we determine how much power we need, which types of power plants we need, both now and into the future? And then, so that's the resource adequacy issue. And then there's grid reliability. How do we make sure the grid is reliable in day-to-day activities, as well as when it's under stress during extreme weather events or heat or drought or those sorts of things. So this is a complicated chart that I could probably spend 2 hours explaining, but I will not. So right now, the Federal Power Commission eventually morphed into what is now the Federal Energy Regulatory Commission. So FERC is in charge of those same things that the Federal Power Commission used to be in charge of. And it addresses resource adequacy through regional transmission organizations. Also the North American Electric Reliability Corporation, which FERC regulates but is in charge of grid reliability. That in turn works through regional entities. There's some other planning entities because we don't have these RTOs all over the country. The RTOs run wholesale electricity markets and also do planning of the electric grid within their region. They're all working with our investor-owned utilities who are building all of these things. And then you also have states. There's a very important role for states, and working through their public utility commissions, they are also regulating the investor-owned utilities, looking at what types of power plants they should build and when they should build them and what the cost should be. So all of these entities are working together. Now, there's an agency that you don't see on this slide, and that's the Department of Energy. The Department of Energy has a very different history coming out of the Manhattan Project during World War II, and it wasn't created in its current form until 1977, which was the same time that the Federal Power Commission went away and FERC was created. So today, DOE's responsibilities include all of our national laboratories, developing and enforcing appliance efficiency standards. That's something that I worked on when I was in the Biden administration at DOE. Also, the emergency authority under Section 202C. So when the FPC became FERC, that 202C authority didn't go to FERC, it went to DOE. Okay, so after the war, what was the exercise of authority under 202C? What did it look like? The FPC continued to use the authority until 1977, then it went to DOE, but basically all of the orders that have taken place between post-World War II and 2025, lots of interconnection orders, particularly after the war in the 1940s and the 1950s, some in the 1960s. Also, as we now had air pollution limits on power plants, there would be orders allowing utilities to operate those power plants in excess of environmental permit limits in emergencies, extreme weather events. They would go to DOE to get basically authority under 202C to do that and not get in trouble with environmental regulators. These were also issued in circumstances like the California electricity crisis in 2000. In almost every case, these orders were issued in response to requests from either a state, a utility, or a regional grid operator. DOE didn't do it on its own in the modern era. And these orders were also issued for very limited time periods. Sometimes it's a few hours, sometimes it's a few days during a heat wave or a hurricane, maybe a few weeks. Okay, now it's 2025, we're in the Trump 2 administration, and we have a series of executive orders. First day in office, declaration of a national energy emergency. Our prior policies trying to promote renewable energy and have a diversity of energy sources, that was bad, right? The assessment is that was bad for the nation. We need to go back to coal, to gas, nuclear, traditional energy sources. This second order on unleashing American energy really set out what we sort of now known as the current Trump administration's energy dominance agenda, which is very, very fossil fuels focused. At the same time, there was a series of orders saying, we want certain types of energy, but all this renewable energy, we don't want it. So agencies make sure this doesn't get built. So no more offshore wind, no more permitting of wind or solar on onshore federal lands, and basically directing the agencies that the administration is in charge of. This is mostly the Department of Interior in the case of offshore and then onshore wind on federal lands, no permits for these projects. Another series of executive orders basically saying wind and solar energy are bad, we need fossil fuels, and it's now US policy to repeal any tax credits, any support for these types of energy resources. Now, at the same time this is happening, there's a historical sort of backdrop here. Coal is coming offline. The coal plants are old. It's obviously more polluting than other energy resources, and it's increasingly expensive for consumers. So you see from 2011, going down to about 2004, a lot of coal is getting retired, being replaced with gas, wind, solar, and then a lot of announced closures through 2030. So, and of course, the coal industry is an industry that President Trump, even from his first term, has really said he's going to support. So he wants to reverse this trend. And you can also see it in these maps here. So the states in brown, this was in the year 2000, these were all the states where coal was the primary resource, the largest percentage of energy resource in the state. Now you look at 2024, there's a lot less states in brown, lots more that their primary energy resource is nuclear or wind or natural gas. This is showing the capacity factors of coal plants, which is basically, if it could run 24/7, 365 days a year, what percentage of that is it actually running? And you see that between 2010 and 2024, it's gone from basically 67% of the time to 42% of the time. Why is that? Most of it are these regional wholesale electricity markets that are looking for the least expensive energy at any particular time, and this is no longer the least expensive energy at any particular time. So in comes 202C. The administration says, what can we use Section 202C for? We can do that not through this whole resource adequacy long-term planning framework. We can just come in and issue orders, no notice, no comment. We can do what we want. And that's what started happening in May of 2025. The administration issued a series of 202C orders for coal plants in Michigan, Washington State, Indiana, and Colorado. These had gone through a long-term resource adequacy process and were scheduled to close. Replacement resources had already been acquired or built, and all of the grid operators and regulators and states had signed off on this. So oftentimes, in the Michigan case, 2 days before the plant was going to close permanently, this order comes in. You must operate this plant. Nobody requested any of these orders. So that in itself was unprecedented. No state asked for this, no regional grid operator asked for this, and certainly the utilities did not ask for this because there's significant cost with trying to keep these plants online and running. This shows where those coal plants are and their size. The one in Michigan particularly is over 1,500 megawatts. That's a really big plant. And everyone in Michigan, the utilities, the states, and the regional grid operators say, we do not need this plant. It is not providing energy for the grid that we need. This is what was supposed to be built just this year between December 2025 and 2026. This is from the Energy Information Administration. You see all of the offshore wind. Green is wind, orange is gas, purple is battery storage, and then the yellow, you can't see the yellow very well here. Actually, that's all solar, it's not gas, sorry. The dark brown is gas. It looks more brown here, but all of these sort of medium color ones, that's all solar. That's what was supposed to come on to replace coal and other things that are going to retire and also address our increased electricity demand. But of course, we have those executive orders saying, no, 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 we don't like this kind of energy. So that's not going to come on. So I have a few graphs just to show what an outlier these current orders are. So this looks at 202C orders by decade and type. The green ones are basically these wartime grid expansion orders that I talked about. And then there's a few peacetime ones here later in the 1940s. Here we've got some additional ones like that. The darker colors here are where the DOE has approved plant operation in response to a request. All the yellows are 202C orders in response to weather problems like blackouts, hurricanes, heat waves. And then the red are these new 202C orders that the Trump administration has issued to the coal plants that I showed you there. This one kind of takes the wartime orders out, because obviously there were a lot of those, and looks at just 2000 to 2025. The other thing to think about is there were no 202C orders in the 80s and the 90s. This was not a power that was used very frequently. But then when you get to the 2000s, we have climate change is becoming a problem. We have a lot more extreme weather. And so you see an increase in these weather-related 202C orders. And then you also see, again, these sort of purple ones where either a grid operator or state or utility said, hey, can we operate this plant above our excess limits because we have another plant offline, something like that. It's only when we get to 2025 that we see these unrequested 202C orders specifically for coal plants. We can divide it up by presidential administration. And you see this is not like a Republican-Democrat sort of thing. And then this is going back just from 1945, so again, taking the World War II ones out of it, and you just see what an outlier these ones in red are. So there's a lot of implications that we can draw from this. I'm guessing my time is up. I don't have a clock here, so I'm going to stop talking now, but happy to talk about in the Q&A about any of the litigation and kind of what this means for the use of presidential power over the electric grid going forward. So thank you.
Thank you so much, Professor Klass. That was amazing, and the statistics that you gathered, I'm sure will generate a lot of questions. I now want to turn it over to the Honorable Matthew Brotmann, Head of Regulatory and Public Affairs and Senior Counsel for Equinor's Renewables Portfolio in the Americas, and also a distinguished visitor and lecturer here at GW Law School. So very excited to have you here, and I'll let you take it away.
Thank you, and thank you for having me back. For anyone who is concerned that in this panel we were going to solve all the problems. Rest assured that is not the case. There are jobs for students going out into the energy and environmental world, so we will not do that. I will also share, since you talked about your long-standing relationship with Professor Klass, I am sitting next to somebody who I shared a dorm with my freshman year of college. So this is like really cool to be on this panel, so this is super exciting. And thank you for inviting me, and it's great to be back here. I had prepared some notes maybe a week and a half, 2 weeks ago, shortly after we did our prep session, and there has been so much, oh, sorry, thank you. So much shifting in the paradigms surrounding energy law that I kind of had to throw those up. So I put down some new notes. I apologize if I'm reading on occasion, but I will do my best to just share some of my thoughts. So by way of background, the company that I work for, Equinor, is a Norwegian-owned power company. We have oil and gas assets. We are the 5th largest by equity producer of oil and gas in the Gulf of America. I work on the power, what we call the power side. I focus primarily on renewables. And so what I bring to this, I hope, is that I sit at the intersection between what the grid needs in terms of reliability, but also responsible transition towards a more renewable future. And so that's something that I'm working on actively every day. We've taken a few steps back in some of our U.S. holdings, unfortunately. We've not been able to build offshore wind at the pace that we would like. But it is fascinating. I should also say that what I say here today is my own opinion and not that of the company, but I'm happy to share my opinion. Yeah, so just try and stop it. Anyway, so a few thoughts I had as I approached the discussion from the perspective of somebody working in a broad energy company. We have oil and gas, we have low carbon solutions, lithium, renewables, as I said, including major offshore wind projects around the globe. It is a fascinating time to be working in this. We were talking about this earlier, that the challenges that we face as lawyers, as policy people, are once in a lifetime, hopefully once in a lifetime, or maybe beyond. And so having a well-prepared group of students get out there, working and interacting with practicing professionals is essential, regardless of where you fall on the political spectrum, quite frankly. We need to navigate this. One of the areas that we are starting to see bipartisan consensus around is reliability and affordability. Now, out of the darkest days, maybe there's a glimmer of hope. I don't see Congress doing much with it in the next couple of months, but we shall see. There is a common language, which I think even 6 or 7 months ago, we weren't even having the same conversation. When you talk about renewables, people just turned it off. And now I think you can have people on both sides of the political spectrum talking about that, because prices are going up for everybody, right? The energy flows, the electrons go into your house. They don't know whether you're Republican, Democrat, Libertarian, Democratic Socialist. It doesn't matter to the electrons, and it doesn't really matter to the grid operators either. So it's a very interesting time and a very timely moment to have this panel. Where I've really been focusing is, my thoughts about this was on some of the cases which have recently been decided. And by recent, I mean over the last year or two, but also, as you're probably aware, of the endangerment finding that, the rescission of that finding that Administrator Zeldin has been touting and traveling the country talking about. As a developer of major infrastructure projects, you have to have a long-term perspective, right? And what is essential in a long-term perspective is predictability. This is both from a CapEx, capital expenditure perspective, as well as just from a grid reliability perspective. If you look at a typical offshore wind project in the US, you're talking about, we purchased a lease for Empire Wind, which is off of Long Island, which will introduce power directly into New York City. It will power about 500,000 homes. That's about 800 megawatts, so it does put in perspective how enormous the coal plant in Michigan is. That's almost twice as big, producing power that nobody really wants. I guess the Department of Defense has been ordered to take on coal as a power source. Nevertheless, we've already had something like 3,000 people working for us on the project, mostly union labor. It's just an enormous project. It delivers clean power directly into an overtaxed infrastructure grid. But we got the lease in 2016. We're going to have first power in 2026. Right? That's a 10-year planning cycle. So if you do the math, even a change in administration doesn't give an investor the confidence that they can move forward. So even if we have, let's say, a Democrat or a Republican who supports offshore wind as the next president, right? That's only 4 more years. Any project in the hopper, there could be a change, right? So what we as developers need, and where we as lawyers really need to get in there, is to give certainty for investment, right? Congress doesn't seem to be doing it, but maybe the courts will help us. We'll have to see, but it's something that I think is a key area, because if you look at all the projects that were canceled that we saw on the slide from Professor Klass, you know, those may not be coming back. If you have a foreign investor or even a domestic company, they'll say, well, do I really want to invest in this? Do I want to upgrade and spend the money to improve the grid when I have no guaranteed return on investment? You know, you can look at, I think offshore wind and onshore wind have written down something like $21 billion in assets this year. That's in 1 year, saying that the value that we had placed on it and represented to our shareholders, it's no longer there. And it may never come back. So it is a precarious time, because at the same time, we're also looking at, I'm way off my script here, by the way. But at the same time, we're also looking at what we know to be increasing energy demand. I mean, everybody wants to talk about data centers and things like that, right? I should also say that I have the title of both Head of Regulatory and Public Affairs and Senior Counsel. My primary role is Head of Regulatory and Public Affairs now, which is why I'm probably talking a little bit more about that than case law, even though I said I was going to talk about case law. Nevertheless, let me get to some cases that we find to be interesting opportunities, shall we say. The first was West Virginia versus EPA, which reframed the limits of the agency authority, and that was under the major questions doctrine, raising the questions about how far federal agencies can go in shaping. I think that was a bit of a preview of what we just saw happen last week with the rescission of the endangerment finding, right? But that was setting that up. This was a sophisticated legal approach to try to take this on. The next I highlighted was Sackett versus EPA, which narrowed the scope of federal jurisdiction under the Clean Water Act. It's just a very specific example, and that affected siting and permitting for both renewable and conventional energy projects. And of course, the court's retreat from the broad deference to agency interpretations adds extra uncertainty into the planning process. At the agency level, FERC is at the center of several paradigm shifts. The Commission's efforts to modernize transmission planning and cost allocation, particularly through Order 1920, represent one of the most consequential regulatory undertakings in years. And for renewables developers in particular, expanded regional planning and long-range transmission development are essential. So for companies with oil and gas assets, FERC's evolving approach to pipeline certification, greenhouse gas considerations, and environmental review continue to shape investment decisions. I think if you pay attention to offshore wind, you'll know that there was a stop work order on our project, Empire Wind, but the first stop work order was lifted. Many people say, well, it was a deal that was struck with New York to allow what's called the NESE, which is the New England Supply, NESE, let's go with NESE Pipeline, owned by Williams, that will also introduce power directly into New York City. And whether there was a quid pro quo, of course there was not, as far as we know there was not, but we worked very closely with the governor's office as well as the federal administration to try to find a solution. Whether there is a solution to the most recent round of stop work orders which were received, you'll probably also know that there were 5 cases challenged in 3 separate courts, all of which the developers actually prevailed in getting preliminary injunctions. Most of those cases are proceeding, our case is proceeding on an accelerated schedule, and the government has not appealed the ruling in the preliminary injunction, so we're still allowed to build. But again, from a developer's perspective, how much more money do you want to sink into a project? And these that one wind project is about between $8 and $9 billion. This is a major investment, even for a large international company. And so how much confidence do you have that another stop work order won't come or another injunction of some kind? With regards to permitting reform, it's another area where change is accelerating. Or at least the talk about it is. At the state level, there has been real movement on that, and maybe that's one way to address some of the lack of movement at the federal level. I mean, we right now have with an executive order where the Secretary of Energy, or Secretary Burgum, actually has to approve any wind permits, so that's Department of Interior falls under him. Even for minor projects, this is unheard of that this would go to a secretarial level approval on just an ordinary run-of-the-mill permit. Obviously, this is a bottleneck that developers are trying to get around. So beyond US borders, and I'm going to pivot a little bit, in the global regulatory pressures, this is not just happening in the United States. You have a number of countries that are walking back their climate goals. They've not unsigned from the Paris Accord, but even Germany, which was at the forefront of offshore wind development, green energy, has recommitted to nuclear as well as to keeping gas-fired pipeline, gas-fired generation online for much longer. That largely is a byproduct of supply chain issues as well as the invasion of Ukraine by Russia, which rejiggered everything in the European, well, not everything, but most things in the European grid, shifting it much further west and north. So you've got international climate reporting standards, which the US no longer applies to. I will tell you, this is an interesting kind of twist in that many of the US oil and gas companies in particular don't want to walk away from those. Because if you sell your products, LNG and things like that, in Europe, or somebody who has those standards, you need to be able to certify that they were generated in a way or produced in a way that meets their standards. If the US eliminates our standards, there's no way to certify that. So many of the companies are voluntarily doing that, much to the, I wouldn't say, it's not in line with our current administration's view of how it should be done. But these are big companies and big donors to the administration, and we'll see where that settles out. But it is not so easy to say, well, yeah, you're going to save all this money because you no longer have to adhere to these standards. The companies, and whether you look at emissions from tailpipes, whether you look at generation, methane accounting, all of these things, the major companies are still going to do it. So this is where private industry, the private sector really has the ability to shape industry as well, or shape the future of energy, I should say. Trade policy, obviously a major issue. We are eagerly awaiting the Supreme Court's ruling on IEEPA tariffs and the President's authority to impose those. The next shoe, of course, will be the 232 tariffs that are being currently investigated by the Department of Commerce, where those fall out. Many of those target specifically energy, renewable energy sector, but will have unintended consequences on oil and gas as well, whether it's steel tariffs, things like that. So that's an area that we're really focused on as well. And taking these together, whether it's trade policy, whether it's permitting, whether it's executive orders, taking those all together, the developments illustrate why the paradigms of US energy are shifting. The frameworks that govern the last generation of energy development are being tested by the demands of the next one, certainly. We have 5-6 years ago, the growth of data centers and AI was not anticipated. Most of the RTOs and ISOs have to do new remodeling, and then they don't have certainty as to what power generation is coming online, so it's very hard to forecast that. This results in over-reliance on outdated technologies and old plants. We have in New York City, we have a number of peaker plants that have been kept on I used to work for the New York Power Authority. I have probably 4 or 5 plants that I worked on the decommissioning of, which are still functioning, and that was 10 years ago, because there's no other alternative. So it's a sad state of affairs, to be fair. So for companies like mine operating at the intersection of renewables and hydrocarbons, domestic regulation, global markets, the challenge is not simply keeping up on the paradigm shifts. It's navigating a world where the rules themselves are constantly in motion. So with that, I will leave some time for, I know we're going to do questions all at the end, yes? So I will conclude my remarks, but I'm eager to hear some of the questions from the audience, crowd.
All of the above.
All of the above. But
It's
anyway,
like our
so-
energy solution needs to be. There you go.
Thank you again for having me. It's really fun to be talking about this.
Thank you so much, and by framing. Thank you so much, and by touching on global issues, I think you had a very nice segue there to our final panelist, Dr. Carolyn Kissane, who, and I'll sneak around again, and we'll scoot around so everybody can see your presentation. But Dr. Kissane is the Associate Dean of Graduate Programs in Global Affairs and Global Security, Conflict, and Cybercrime at the NYU Center for Global Affairs, and also a member of a number of significant international associations, including the Council on Foreign Relations. I will say, if you haven't followed Carolyn's Substack, followed her rather prolific energy communications, I would suggest that you do so because she's an extremely effective communicator about all of these issues, in addition to being a great expert. For those in the back of the room, there are plenty of seats in the front. I'm going to just go over to the side here and I'll let you take it away.
Well, hello. Thank you so very much. Good morning, everyone. It's wonderful to see you all out. When I was leaving the hotel this morning, it was pouring rain, and I was a little nervous that, but this is a great turnout. I am really honored to be here. I have to say, I feel a little bit like an imposter. I am not I don't teach law. I do not have a law degree, but I am deeply grateful for those of you that are here, those of you that I had the opportunity to hear from yesterday in terms of the work you're doing. And I think, Professor Klass just earlier, the Honorable Brotmann, which I love being able to say that, is someone who
I love hearing you say it.
I just really want to, at this time, the work is so critical, and a lot of gratitude. For those of you, the students in the audience, you are entering, I think Professor Busby, who's here from Georgetown, he said as sort of policies unwind, it means that there's great demand for lawyers. So just gonna say that. So I'm kind of gonna take a little bit of a different sort of looking at kind of the international. I'm gonna do a little bit of the domestic. I know there are a lot of students here. This is a, kind of, for those of us that have been in it, it's, sort of, again, as the Honorable Brotmann said, just in this last week, we've seen such an onslaught, right, with the repeal of the endangerment finding. But if we think about this, sort of going back to 2008, and kind of understanding the backdrop of how sort of the shifting paradigms and what it actually means. So again, don't need to kind of go through this, but just to kind of take you here, and then sort of a timeline of what I call policy regulatory whiplash. And that it's been quite extreme. And to Matt's point, right, if you are a company and you're working in this space and you need legal certainty, you need some policy certainty, you need to sort of understand that the regulatory environment is stable in terms of as you make some very significant, very long-term investments. We're not in that time now. So just in terms of looking here, again, Professor Klass talked about Donald Trump's energy dominance agenda, which he launched in January of 2017, first day in office, which very much was about what is a very sort of hydrocarbon-centric position: oil, natural gas, coal, some deregulatory reversals, the very quick withdrawal from the Paris Agreement, again, hydrocarbon prioritization, administrative rollback, again, lots of policy oscillation and administrative turnover. But then, of course, we go into the Biden administration, which is very climate forward, very industrial policy forward as well. If you sort of look at the Biden administration, one of the things that was very sort of clear from the onset was that this was going to be kind of an all-of-government approach to addressing climate change. We saw that, and again, thank you, Professor Klass, for all the work that you did, but very much sort of thinking about what the United States needs to do to be a leader in the climate space, to sort of push forward renewable energy, and also to, sort of build out the industrial base that had been lost decades before. And then, of course, now we're in the sort of the second iteration of Trump, which again is, I think, an even more intense regulatory reversal, challenging institutions. Again, just last week, the endangerment finding repealed, blocking offshore wind projects, solar, really sort of making it very, very difficult to build renewable energy. It's been very sort of resource specific in terms of what the administration sort of approves of. And to Professor Klass's point about resource adequacy, makes it very, very difficult in terms of planning. So I'm not going to go through this in great detail, but just to the point that if you look at U.S. power generation capacity by source through 2035, And again, I think it's really important. We're looking at, again, the numbers vary, but you're looking at potentially up to 13%. Again, generation capacity is projected to rise by 13% in the next decade. We are looking at increasing power demand in a way that the electrical sort of system in the United States has not seen for decades. And to the point of affordability, we're already seeing across the United States, real challenges in terms of around electricity affordability. We are seeing even in terms of its bill, it's also building into something of kind of a unique in terms of areas of opposition to new infrastructure build. We're seeing that also, especially in the data center space, which I'm also happy to address, because I do a lot of work in that space. But again, much of what we're looking at in terms of new generation capacity was expected to come from solar, battery, and wind power expansions. So as we sort of see these rollbacks that are in play, how we're going to meet this demand moving forward, I think that we can only do it through natural gas and the kind of renewal of coal generation, I think is very short-sighted. So something that I do, I teach in geopolitics and energy. I do a lot of work in energy security. In fact, this morning I started with phone calls about what is going to happen to oil prices if the United States takes action in Iran this weekend, right? And what is that going to mean? Again, if it's going to be sort of a short period of time, it's going to be a long period of time. 7 weeks ago, 8 weeks ago, I was getting phone calls about what does it mean when the United States, captures Maduro, right? What does it mean when the United States is going into Venezuela? So in terms of thinking about the geopolitics, one of the things that I've been also spending a lot of time on is sort of looking at what other countries are doing. And I think, China, I think, is one of the most interesting cases. China is what is considered to be the archetype electrostate, meaning that they are sort of building out a lot of generation capacity specifically to support electrification. And if you're China, right, and you are import dependent, for example, on oil and natural gas, that is a source of insecurity. That's a source of insecurity in terms of China's national security. So they have been very, very intentional about building out a huge, massive generation that is really the all of the above. Okay, a lot of wind, a lot of solar, hydropower. They continue, of course, to rely heavily on coal, but actually in 2025, you saw a reduction in emissions from coal in China, and you're starting to see, in fact, what will be the plateau in coal consumption in China, while they build out very significant, have here in terms of just looking at net growth from non-fossil resources. Just to put it into perspective, in the last 4 years, China has built out more generation than the entire United States, okay, in power generation. Just in the last 4 years, they're building it out at such a massive scale and at speed, and they're doing it again. You could, again, depending on who you talk to, it's not necessarily to achieve China's stated climate goals, but of course it also means that China is in fact reducing emissions as they build this out. If you turn to India, India is the sort of the fastest growing kind of country in terms of energy demand. And one of the things that's very also interesting to see is that if you, very sort of similar in terms of population, 1.3 in China, 1.4 in India, but India is actually, what we're seeing is sort of taking a bit of a different trajectory as they sort of build out energy security. And they are actually very much sort of focusing a lot more on what they can do in the non-fossil space. Coal continues to provide about 70% of electricity generation, but here, what I have here at the bottom of the page, electrifying faster and using less fossil fuel per capita than China did at a comparable stage. I think this is really significant because, again, it makes sort of what we're seeing in the United States as not in line with where many countries have gone and are going as they think about building out larger scale energy security and electricity security, because electricity security is so critical for so many of the sectors, the growth sectors, in terms of economic competitiveness. So again, if we're thinking about AI and what is required in terms of data centers, very, very important to have lots of ample electricity, and this is something that we have seen that China has very much taken the lead. They're also exporting their sort of infrastructure. Not just are they exporting solar panels and wind turbines. So one of the things that I think is really important to sort of recognize when we're sort of thinking about this paradigm shift is that many of the industries that really started here in the United States, that the United States was very much a leader in, have now been overtaken by China. So even like nuclear energy, for example, China is building out nuclear power, again, at a speed and scale that is, and they're doing it, and they're also taking those technologies, and they are exporting the technology. They're also exporting a lot of the critical infrastructure. And I'll just sort of step back for a moment to also sort of say what it means for sort of, Matt had mentioned in terms of if you're sitting, for example, in Europe right now and you're looking at US energy policy and the rollback of climate policies, you're asking a lot of questions, not just about in terms of the reliability of what has been sort of an 80-year sort of friendship and very strong alliance, but last week during the Munich Security Conference, European buyers of US LNG are now questioning whether or not they will continue to buy at the scale that they earlier committed to after the 2022 invasion of Russia's invasion of Ukraine. And for the United States, for private companies now that are sort of sitting and they're like, we're now sort of at the mercy of the sort of US government sort of very vitriol rhetoric around sort of climate. And just this week, Secretary Wright was in Paris at the International Energy Agency, and the United States is threatening to rescind 14% of funding that goes to supporting the IEA, and they're rescinding that because they want the IEA to basically kind of erase climate change from their modeling. And so if the United States pulls out of the IEA, of course it makes much of the research and much of the that's very important in terms of for understanding global energy. So just to say what's happening in the United States in terms of these rollbacks have very significant global implications for sort of how countries are not only sort of thinking about their relationship and their trade relationship with the United States, but also how they think about their the reliability of the United States as a trade partner in the energy space. And I'll just sort of end, because maybe I'll end. Hold on a second. Maybe I'll end here. I have one more slide that I'll maybe get to. Okay, maybe it's missing. Okay, but this in terms of what we see sort of here is the so many sort of issues that are coming into play that I think are when you think about sort of future energy sort of growth in terms of what is required, again, this oscillation on regulation, this sort of shifting, all of this discontinuity is actually hindering the United States, not just its sort of overall economic competitiveness, but also its geopolitical position. The last slide has just a piece that I just published yesterday in Foreign Affairs, and it's called Energy Dominance with Chinese Characteristics. And it's somewhat controversial. There are a lot of sort of challenges in China's energy system, but they have in fact built a system that is becoming much less fossil dependent. And that is incredibly intentional. And I think when you sort of think about the scale and how China has been able to sort of reduce the price for solar, for example, for wind, when you're looking at those of you that are interested in sort of emerging economies and you're basically looking at now a model that is much more replicable. So if you're Pakistan, you're Bangladesh, you are a country in Africa, you do not have to necessarily sort of think about a sort of a very fossil dominant future. You can think about a future that is much more heavily reliant on electrification and the infrastructure for electrification. And the last thing I'll say, which is very interesting, Ethiopia has a ban on internal combustion engines. It's sort of slated for about 2030. They're building out electrification to support EVs, and they do not want gasoline-powered cars. And we're seeing that in sort of across many countries, young populations that really want to sort of see that sort of shift. So I think we are in a very sort of unique time, and I think what we're seeing happen here in the United States, again, has very significant global implications. Thank you so very much for your time.
Thank you to all of our panelists, and I'm going to stand up actually before I sit down. So in my classes, I always tell students, you're on call. You got to think on your feet. You have to synthesize lots of information that's coming at you at once. And this panel is going to give you guys the opportunity to show them how it's done, because I believe the legal landscape just shifted as you were talking. So thanks to Mr. Tokheim in our property class, who I was sitting next to, we just found, he just sent me the decision in Learning Resources, Inc. versus Trump. The question in that case, does the International Emergency Economic Powers Act authorize Trump to impose tariffs? The Supreme Court has answered, and they said no. So in a 170-page opinion, which I only read about 40 pages of on my phone while I was looking over there, there were a number of opinions. Chief Justice Roberts delivered the opinion of the court. Justices Thomas Kavanaugh and Alito dissented. So I'm just going to read you a couple of things, and I'd love for you to respond. So here's something from one of the concurrences, Chief Justice Roberts' concurrence. There is no exception to the major questions doctrine for emergency statutes, nor does the fact that tariffs implicate foreign affairs render the doctrine inapplicable. That's one little factoid, little excerpt. Another thing is they quoted West Virginia versus EPA early in the decision, reiterating in that decision the court showed reluctance to read into ambiguous statutory text extraordinary delegation of congressional powers. So now you know this pressing decision has just been made. As the dean said, there's no better place than GW Law to hear from experts about modern and contemporary issues. So with that, that's my first question. Please discuss.
I will start with my first reflection, which is, yes, thankfully we got this. And I will say that for a few reasons. One, from a developer's perspective, who in our projects in the US, we've incurred probably in excess of close to $1 billion of costs related to these tariffs. So from our perspective, do we ever get that money back? We'll see. I don't know if in the 170 pages they discussed how that was going to be done. But I also will say that in discussing the IEEPA tariffs with other counsel developers, but also our external counsel, it was really seen as a test of whether the court was going to stand up to the administration. On the legal basis, everybody felt that there was a good case that these should be, the executive authority to impose these should be clipped, right? That But the question was whether this court was going to do it. So I will say it is a victory not just for those who were directly impacted, and considering that 90% of the tariffs have been paid for by US consumers, it was basically everybody. But on a large scale, it was also what I would say another sign that the courts are still functioning as a check on the executive. I know that often we don't see that happening, and there are many examples where that hasn't, but if you say that the legislative branch has ceded much of its power to the executive branch, then the only check on that is the judicial. And I think what we've seen here, again, not having read the opinion, but what we've seen at least is some kind of check on that. Now, I'll add one last note, putting on my developer hat again. Now we worry about the 232 tariffs, because this administration has lost again and again and again on its overreach. But one of the areas that they can resort to, which is firmly within the executive, it can be challenged, but it's a much more difficult process, is these other what are called Section 232 tariffs. So we'll have to closely monitor that, but yeah, I'll leave it at that. I bought you guys time to get your.
I'll just say, in a time that we've been hearing so much bad news, it's really wonderful to sort of have some very, very, very good news. I'll leave it to sort of our legal scholars to sort of really address it. But one of the things I think on the tariffs is I was in Houston 2 weeks ago, and to Matt's earlier point during his presentation is that yes, hydrocarbon firms, oil and gas companies have been really, in terms of the tariffs, the steel tariffs, have been really, really, have a hard hit, right, in terms of their operations and to their costs. And I will also just say, it's very interesting, so if you go back to Liberation Day last April, I know, forgive me for even saying that word, that term, but if you go back to that, Trump more often than not blinked first. So meaning that sort of when these sort of very large 50% tariffs and 25% tariffs, there was always like a eventual step back. China is one good case in point, but again, a lot of it was a lot of sort of deal making. But I think this idea that the Supreme Court, has sort of come out and said that they are in fact unconstitutional and that overreach, I think is important, not just on the tariff front, but the larger that I think for Americans to see that the Supreme Court still has, right, the muscle to stand up to the administration.
So I'll provide the important caveat that I need to read the decision first to see how helpful it is for the things that I've been talking about, but it certainly sounds promising, right? So, and the idea that there's no exception to the major questions doctrine for emergency action seems, depending on how, that's actually discussed in the opinion, seems super helpful for the 202C litigation that's going on right now in the DC Circuit. Major questions doctrine is an issue in that case. Obviously, that's very narrow authority that's never been used in that way. And in fact, in the first Trump administration, there were requests by coal companies to use 202C authority to keep coal plants open. And at the time, the Department of Energy and the White House was like, we don't really think we can do that. And those voices are not present currently. So I think that this is potentially helpful in terms of seeing whether, I still think there's a question as to whether courts will apply the major questions doctrine in to apply to sort of deregulatory actions versus typically it's been used for Democratic presidents trying to create additional protections. I guess this will be a test for that. But then there's also things like the federalism canon in terms of taking authority away from states that is at play in this case, and then also, as I mentioned before, taking usurping authority from the agencies that Congress put in charge of doing things. It may be that this case can be quite helpful there, but we'll need to see how broadly or narrowly it's written.
All right, 170 pages later. I had another question for you about culture, but I see Professor Glicksman's hand up, so.
I just wanted to clarify that the portion of the opinion dealing with the major questions doctrine was a plurality, not a majority.
Yes, that comes in
Justices
concurrence.
refused to join that part of the opinion. The liberal justices, as far as I can tell, want nothing to do with the major questions doctrine. So they're not going to weigh in about, well, does it expand this far? Does it? They just don't buy into it. So the majority portion of the opinion is based upon, quote, traditional statutory interpretation. And they say the statute just doesn't reach this far. So I don't know that we have
I can live with
a whole
that.
lot of additional learning or binding precedent on the major questions doctrine portion.
Yes, I did, hopefully I specified that was in one of the concurrences written by Chief Justice Roberts, but if not, I will reiterate. 170 pages, somebody's got to read this. I'm sure we're all going to do that right after this. Okay, I do want to ask a question. So I didn't see other hands, so I will just ask one question. Putting that aside, that big news aside, I did want to ask you all about culture. And so as you know, I led the Federal Historic Preservation Agency during the Biden administration, and that agency has a process before any project can be built. If there's a federal dollar or if it's a federal project, if it's on federal land, it has to go through a review process to balance and evaluate the impacts of that action on historic properties and cultural properties, including tribal property. To what extent do our energy needs trump those cultural values? How do we resolve those? That was something that we tried to grapple with, and we did a few things on building-related energy efficiency and building-related solar. But the big projects, the solar, the wind, these are all issues that implicate large-scale cultural landscapes in many cases. So I just was super interested to hear that about that. If anybody wanted to touch on that in their experience.
So let me make sure I know what you're asking. So looking at the question of when you have sort of local opposition to particular projects by saying it's disturbing existing lands, and how we deal with sort of building new infrastructure in light of that, is that
Really,
what you're asking?
I'm thinking more of the aspects of culture. So for example, Cape Wind and the challenges from Nantucket homeowners and their visuals from their historic district, as well as tribes and their traditional worship-related landscapes. So those issues came into play through the federal statute, the National Historic Preservation Act, that the agency I worked at administered. And to me, you know, the balance of culture and energy needs was obviously one of the main things that we thought about, and I don't have any good answers. So I thought maybe you all would
I'm
be
happy
able to
jump into
delineate. Thank you,
Yeah, and I
Matthew.
have some thoughts too, but go
Oh,
for it.
I will say that the cultural reference that you make is, for example, Empire Wind has an extensive Section 106 tribal engagement strategy. It is interesting that many of the provisions that you would think this current administration would not be eager to enforce, that is a condition of our construction operations permit, the COP. And so we are, and as a company, we would actually, of course, adhere to that anyway, but we engage actively with a number of the federally recognized tribal nations. There are those that are recognized by New York State, for example, that we engage with. And that includes, as we lay our inter-array cables and our transmission cables, which are starting 16 miles off the coast, tribal nations can monitor all of that remotely, or they can be on the vessel, so that they can see whether anything on the seabed implicates their cultural heritage and what we would need to do about that. We've not found anything. It is a robust program. I will also say that one of the things that we've done is we are building our terminal that will support this in an environmental justice community in the heart of Brooklyn, in Sunset Park as an area. Those are obligations that we've committed to. New York State has imposed upon us. The federal government has imposed some as well. Those are all robustly being enforced. This administration has not backed off of those, and it is incumbent upon all the developers. Honestly, it is our license to operate. That's the way we see it. And I will tell you that I think that is similar with most, and we are, as I said, a broad energy company. We're Norwegian owned. We tend to be quite sensitive to those things at a leadership level. But most of the oil and gas companies that are operating in the Northeast are very sensitive to that. We had a project that was going to introduce power onto Long Island. This is not an EJ community. This is not a culturally sensitive community. And they essentially shut us down. They said, you're going to ruin our viewshed, even though that was not the case. There was a lot of misinformation. This is part of the risk, right, is how do you balance the misinformation, which is intentional, with the legitimate concerns of these communities. So it is something we take very seriously. The government, the federal government, still seems to be actively enforcing it, which I guess is good news. Yeah, sorry.
Yeah, I was gonna say, I mean, there's a process and a balance for all of these sorts of things. I mean, really your question is about, you know, are we gonna allow change of any kind? And some of that is culture, some of that is land use, some of that is aesthetics. And we have a pretty robust process for doing that. But unless we're going to say we're not going to build any new infrastructure, we're always going to have to be resolving those issues. And I think we also have to keep in mind that, like, we have lots of existing energy projects that are impacting tribal resources, that are polluting our air. Unless we build new things, we can't retire the old. It's just that we've gotten used to the old things and all the impacts they have. So they've sort of fallen into the background. And I think we don't think about the fact that if we build new carbon-free energy, we actually get to get rid of the old things. It's not only on top of the old. And I think that's something that's really important to keep in mind. I mean, we need a transition. I think we've lost the idea that we can actually make our world better through building things. And that is a big problem, I think, in terms of environmental groups and others who are often opposing new things, but not supporting good new things as well. And I think, you know, the abundance movement tries to get at that, and I think there's some important ideas in there that we all need to grapple with as we think about what we want our energy future to look like. One of the problems we have now is that the current administration is doubling down on the technologies of the past, and not even embracing the technologies of the future, the technologies of the present. I mean, wind, solar, offshore wind is prevalent everywhere except for here in the US. So these are not like new futuristic technologies. These are what we have now. And I think we have processes in place to deal with land use, culture, aesthetics, and we need to use them and move forward.
I think I saw Professor Stokes with a hand.
Excuse me, yes. So this question is sort of from a developer perspective, so I would love your thoughts. So you mentioned planning and predictability in your remarks, and I'm curious, sort of, how do you stabilize your metrics for predictability in these changing landscapes? Like, to what extent do the market factors, do environmental factors sort of play a part in how you make those assessments? I'm just curious about that. And then you mentioned sort of your license to operate is complying with some of these sort of environmental justice related parameters. So I'm curious, do you find that there's a similar license to operate when you're on the oil and gas side, or is there more flexibility in what you can do because there's less requirements to engage on that front?
And I'll just flag, we have about 10 minutes left in our panel, so we'll keep our answers short, because
Yes.
I did see some more hands.
So the first question is, under other circumstances, ordinary circumstances, if we recall what those were, the costs and predictability, when we look at whether to invest in a project, we have our, you know, what the return on investment will be, and we can anticipate what many of those costs will be. Now, there are externalities. Ukraine was one, COVID was another, where our supply chain costs on certain components were over 100%, the increase. Those are hard to predict, right? And so then you have the company making the decision, do we want to continue with this project? And then you have to balance what the future rates would be. In one of our cases, we actually went back to the Public Service Commission in New York to renegotiate the price that we had set, which met with a resounding no thank you. So we were able to recapture some values there. But it is something that we just recognize that certain times it's fairly predictable. Oil and gas projects used to be very predictable. Now, again, with Ukraine and things like that, less so. To answer the second part of your question, it is, the license to operate in oil and gas is a little bit different in that the primary focus there is also really, it's the number one priority for us is safety on any project we do. But I'm going to give you an example, and I'll leave it at that, which is when Louisiana was looking to procure offshore wind, they were looking to procure offshore wind in state waters, which only go out 3 miles, because they didn't want to deal with the federal government on that. I spoke to somebody down there, I was at Tulane Law School, and I spoke to somebody and said, are your residents actually going to live with wind turbines? These are massive. You can see them from 15 miles, not 16, 15 miles. But are they going to live with them in their backyard? And they said they're used to having oil refineries in their backyard. So it is very context specific. But engaging with the community is the way that we actually can build these projects. Whether it's whatever that community will value. We have a lithium project in a community that is a very different approach to what we can do. They're used to different things. Brooklyn, quite different. Very active EJ engagement there. So it is the need for the license to operate doesn't change. How we receive that license, that's going to be more circumstantial.
Professor Oka.
Fantastic panel. Thanks to all of you, including Sara, bringing in that great I'm just curious about the wind projects. We have 5 losses for the Trump administration on blocking wind. And so for those of us who are in favor of offshore wind, that's good news, but I haven't been able to read anything that gives me the certainty that all of those can go forward now despite the disruption. I know you said you're involved in one, but
Yep.
if you have a sense of the others, are those now all able to go forward?
Yes.
Or was the disruption enough to cause a problem?
So from a legal perspective, all 5 projects under construction received a preliminary injunction, which meant the government could not impose its ban on moving forward with the project. So legally, we can move forward. Now, commercially, whether each company wants to move forward is different, and each are at different phases. So Dominion is much different than, let's say, Sunrise, which is 87% constructed. Vineyard was actually just replacing blades, so that's done. Empire is moving forward. But all 5 have received favorable rulings from the courts, some very strongly worded. None of them have been appealed to date. So right
the
now,
other 3, you don't know if they'll go forward still?
all 5 are going
From a
forward right now.
standpoint?
All 5 are going forward right now. Yeah, it's,
Great. I see another question here. Go ahead. Yes.
Honorable Brotmann, you mentioned that there's bipartisan consensus being built in terms of reliability and affordability. And my question relates to health. Why do you think that it's more difficult or it's not being built around health? Because long-term health effects in some of these communities, what these polluters are doing to them is pretty high and pretty costly. And I work in air quality, and I know that when we go out and talk to these communities, they actually really do care about the health concerns, but it seems like the party's down.
Did either of you want to address that point? If not, okay, go ahead.
well, first I would say there is not necessarily consensus around, it's just that it's a common talking point. Honestly, if it doesn't show up day one, people talk about the threat of blackouts. Until people can't get power, they're not gonna worry about it. What's happening with affordability is people are seeing it on their utility bills. And that's why it's really become this talking point. Reliability is being talked about at a much larger level with the hyperscalers and things like that, the data centers who are really looking at it from, can we build these things? But if it's not something right in front of us, people don't really tend to be motivated by that, and that shows up in the, when we go to the polls as well.
Great. Other questions? Yes, Mr. Martin.
I had a question relating specifically to cybersecurity. So we've seen the impact of cyber attacks on energy infrastructure, both in the war in Ukraine and recent operations in Venezuela. So I'd like to know how the policy instability has affected the ability of grid operators and managers to harden against those sorts of attacks that could come in the future.
I'm going to ask Dr. Kissane this question, and I'll repeat it for those who didn't hear. The question was about cybersecurity and how instability affects cybersecurity, and I think that's right in your wheelhouse, so I'll let you take that away.
So thank you. Yeah, no, it's a great question. I mean, you could any utility you go into today, they have an Office of Cybersecurity. This is, the threats are many. You also have right now, I would say a kind of another layer of threats with, many utilities are employing and deploying AI in terms of sort of grid stability and sort of thinking about sort of the power load. There is real significant concern as to, something that could go wrong, for example. If you go back to the spring of 2021 with the Continental pipeline here in the Northeast, I mean, that was a cybersecurity incident, which had some very significant impacts. So I think that again, really critical. Again, it's the threats are only multiplying as one, you're sort of laying a lot of AI on these systems, and you have many more sort of what we talk about in our program is we talk a lot about non-state actors as well as state actors, who are our grid is a very critical infrastructure in the United States. So there is some motivation on the part of foreign actors to disrupt.
I'll leave it at that.
Great. And I think we just have time for 1 minute of closing comments from each of our panelists. Any last reflections, comments to what others have said?
Yes. So much to say. I think what Carolyn talked about is super important because there are so many geopolitical and economic and national security concerns associated with kind of this doubling down on technologies of the past as China, India, and the rest of the world sort of moves forward. And I do think that dovetails a little bit with the affordability issue. So I do think that voters and everybody else paying electric utility bills are starting to respond to cost issues. You saw in Georgia, public utility commissioners are elected. And 2 Democrats were just elected for the first time in the November elections, and that's really flipping that commission. Why? Georgia brought a new nuclear plant online, which overall is probably a good thing, but the cost overruns were really, really significant. And that type of election is the type of election where voters can say, we have a problem with this, we want to see a change. And so that may also, at some point, maybe not yet, but at some point may be a counterbalance to what the current administration is doing. The actions they're taking are in the name of affordability, but they work in the opposite direction, and people are starting to see that on their utility bills, and that might build some, political resistance to some of the trends that we're all talking about right now. So we'll have to wait and see.
Okay, 1 minute.
Well, thank you, brilliant. I mean, I completely concur. I think what we're going to be seeing in November with the midterm elections, affordability is very much going to be on the agenda. I think I would encourage you to follow Power Lines. It's great. It's been sort of looking at Georgia, Louisiana, in terms of rising electricity prices and sort of the politics of that. And yeah, to that effect, I mean, we do need the abundance agenda, right? We need more, not less. So the fact that we have right now constraints on our system when we actually need much more, and where the scalability is in the solar, wind, battery deployment, and the fact that we're actually restricting is a significant security implication for the United States.
Yes.
You've heard enough from me, so I will simply say thank you for having me, and congratulations for those of you who chose to be here today. What a great time to hear about this, and best of luck as you move forward. There is a need for you, so please stick with it. But
and please join me in thanking our panel. This is how you think on your feet.